rise. The Court of Appeals, Division 1 is now in session.
Thank you. Please be seated. Good afternoon. This is the time set for oral argument in our cause number CV130566. Mr. Foote, you're going to need to help me with that, the name of your institutional client. What's your best pronunciation for it?
She's actually
It's a Rockajou, Your Honor.
Oh, Rockajou. Okay, that's right. You're the appellant, but that you don't care about that name. You care. Rockajou, Inc. versus True North et al. We are recording today's proceedings, counsel, so when you step to the podium, please identify your clients that you represent and pronounce them clearly so that we can once again understand. Each side will have 20 minutes for argument, and Mr. Foote, as appellant's counsel, you're responsible for watching the clock and reserving any time for rebuttal that you might desire. We have read the briefs, we've conferenced the case prior to argument, and with those preliminaries out of the way, Mr. Foote, you may proceed.
Thank you, Your Honors. Roger Foote for True North, Dale William and Christy William, who are in the court this morning. Since you've read the briefs, you know what we're here about. We're here about a forced sale of an interest in some businesses and whether it properly occurred. The Rockajou would like to couch the question as in if there was no valid acceptance or election, what happens? But that's not really the case that you have before you. The case you have before you is a Rockajou able to make more than one election of a remedy? They have admitted in their briefs that they rescinded the contract. As such, they have elected their remedies. In their case below, and in our case here, we've all stated and we all agree that in Arizona, the remedies for breach of contract include 1, damages, 2, specific performance, or 3, rescission. They elected to rescind. They have admitted judicially that they have rescinded. Therefore, they cannot enforce the contract. I thought they might try to backdoor it and say, well, but we only partially rescinded it. And that might give them a way to get to where they want to be. But even in their reply, their answering brief, page 37 says, there was no partial rescission as suggested by appellants, as no part of the contract of appellants to the buyer remained. That contract was fully rescinded. I don't know why they thought they could rescind and then reform and have specific performance, but the law is real clear. Their admissions are real clear. They can't get from A to B. It's really very easy. When you rescind, what happens? All the cases we cited and they cited, it undoes the agreement and they're put in the position as they were before the contract. The contract is abrogated, put to an end. And in their answering brief, this quote is telling from Hall versus Reed, 229 Arizona 277. The contractual remedy of rescission, quote, abrogates the contract and undoes it from the beginning. That is, not merely to release the parties from further obligation to each other in respect to the subject of the contract, but to annul the contract and restore the parties to their relative positions which they would have occupied if no such contract had ever been made. Contrary to the clear law, the court did not put the parties in that position. They partially rescinded. They said, oh, no, you didn't properly make this irrevocable election. If we didn't properly do it, they still only had 3 remedies. The remedy that they selected was rescission. You can't have specific performance after rescission. The law is clear. And that's exactly what happened in this case. The Hennessy Equipment Company case says, you know, the doctrine of election of remedies is to the effect that the choice of one among 2 or other available but inconsistent remedies bars recourse to the others. You cannot rescind and then specifically enforce. Even equity can't do that because we know equity has to follow the law. Equity cannot ignore the law. And in one of the cases that they cited, Losell versus Cosas Management Group, the court also says that if you're looking at equitable remedies, the court has to soundly exercise its discretion. The court must also correctly apply the law. And the law is clear and unequivocal. You can't rescind and then subsequently specific performance. The doctrine of specific performance is also clear. What that does is it puts the parties in the same position as if they had fully performed the contract. You rescind, it's gone. You can't push them back together and make a contract. The other, there's case out there in restatement contracts that says the court cannot, even under equity, make the contract that he thinks that they should have had or what the court would like them to have. That's an impossibility. So not only do we have rescission and then specific performance, but after we have specific performance, they again modify the contract. They reform. You can't have reformation. You can't have reformation and specific performance. You can't have reformation and rescission. They're just incompatible. In order for a contract to be reformed, it has to be reformed to coincide with the express intent of the parties. The court never found that it was the express intent of the parties that if the irrevocable election was invalid, that the rest of the contract would go through and the party who made the irrevocable election is now revoked and the other party comes in there. So it's not part of the contract. No evidence it was agreed to be part of the contract, and there's no evidence that that was what was intended. In fact, the court said...
Counsel, let me ask you.
Sure.
This case was filed about 7 years ago as a petition for involuntary dissolution.
Correct.
And it had, from the record, which is cold to us but known to you, and we have reviewed it, a really lengthy history of pretty active trial court involvement, it seems, as a stranger to the case, including more than one judicial officer who worked with it. And ultimately, the case comes to us through through orders that are almost akin to an escrow situation. Now, that's not probably doing it justice, and I'm not asking you to agree with that terminology, but it's a really unique procedural case. And that is also then magnified by the claim that I want to hear more about from you and your opponent about the acceptance of benefit doctrine. Sort of what happened after these decisions were made and after certain actions and conduct were made and after certain documents and money were deposited with the clerk of court. So I appreciate what you're saying on the contractual doctrines that you're talking about. But I also want to make sure we have fair time to hear fully from you on the acceptance of the benefit doctrine, which is not a doctrine that is applied, every day by this court.
Okay. I've learned through history that if the court has a question, you answer that question. It's important to the court.
I would appreciate if you would at least address it, because it is important.
I'll address it right now. Under Arizona, there is clear case law, Supreme Court, appellate court law, that the acceptance of benefit doctrine applies if there is a voluntary acceptance. That's key in several of the cases. The Del Rio land case specifically says, in a fact situation that is so close to this, it's almost scary. In that case, there was a judgment of foreclosure, and the property had been foreclosed on, and the court said that in addition to having a judgment for specific performance, as we have in here, hanging over it, the appellant corporation was in financial difficulty, which we have the record here. We couldn't post the bond. And the mortgage on the property in the controversy had been foreclosed. That's what essentially happened here. And the actual judgment of foreclosure had been entered. Here we have an actual judgment forcing the transfer. There is no dispute that the corporation would not have been able to file a supersedious bond in this case. And that's true in this case. It says the actions taken by
So let me ask you on the bond front. Did the bonding occur here after the changes to the rules that allow for alternative bond amounts based on the appellant's net worth?
I can't answer that truthfully.
Okay, and
I don't know.
that's fair.
It says the action taken by the officers of the corporation were compelled by the necessities of the situation and must be regarded as compulsory rather than voluntary. That's Arizona Supreme Court law. That's the focus that you need to put on it.
But isn't this different? I mean, Del Rio involved pain of contempt, but also there's nothing that compelled your client to request the disbursement of those funds.
I'll address that, Your Honor. What happened in this case is that those funds had to be put in. We have to look at the whole situation, which they did in Del Rio. And in the whole situation, the company was taken away from my client. He had no ability for any income. That was his income. That was his whole source of income, the only money he had. He had an IRS lien out there. He had other liens on there. He had the attorney's liens on there. Why is that not is that not being compelled? He had no other source to pay these funds. I think what you're really looking at is a separate issue that's not before the court, and that's what happens when we get back at the trial court. And trial court will have to figure out whether they can compel that property to come back. We don't know what that will be. We don't have the facts before the court. But the issue is, look at this practically. That's what the trial court did not do. In fact, the Webb v. Cronin case that's cited in the Del Rio case says, this court has the occasion to examine the question of what constituted involuntary payment. This was clearly an involuntary acceptance. We had to, the property's gone, our income's gone, we have bills to pay. And then again in the Vincent B. Marson case, it says, the court found that property sold under court order of specific performance, like this, that where economic circumstances make it untenable to post a bond, the failure of the bond is not a voluntary acquiescence. So that's what they're looking at. They're looking at what happened at the time of the appeal.
And I understand that, although I want to hear more from you about whether post-appeal events are relevant or not, given your brief. But there's a difference between not posting a bond, I would submit, and seeking and obtaining a court order releasing $1.3 million.
Okay, I will address that.
Well, I appreciate that.
I don't think anything after the appeal is effective as to the question of whether there was a voluntary acceptance of the money. It wasn't voluntary. We had to take it. They had to pay bills. They had an IRS lien on it that had to be paid. All of that was not voluntary in the sense of all of these cases.
Well, and I understood your brief to say that the acceptance of the benefit doctrine looks only at events that occur prior to the notice of appeal.
Correct.
Well, and I wanted, if that's the case, Rosen applied it on, and I'll quote here, on conduct that, and I'll start the quote, occurred after the filing of the appeal. And that's a direct quote from Rosen, and so I struggled with that, and I'd be happy to know more.
I think in the Rosen case, there were a lot of things going on. I don't think that was a material fact. It was something that they threw in there because the Del Rio case doesn't apply there, doesn't say that. None of the cases actually say that the Supreme Court has said. And even in the other case, the Hackett v. Superior Court case, everything had happened, and it was years later that the court said, no matter what happened before, when there was a substantial wrong and injustice in the process, they were going to fix it. And that's what we're trying to do here. There has been a substantial wrong in the process that we're trying to fix. That's the policy of the court, the Supreme Court. Look at everything that's going on and find out whether there was a violation of the process. If there is a violation of the process, in this case, we had no choice. All of our property was gone. What do you do? Again, you go back to the wording in Del Rio. They were compelled by the necessities of the situation. That's what's important. That's what you look at. That's what you consider. And I'd like to reserve the rest of my time for rebuttal.
Thank you. And Mr. Schwartz.
Thank you, Your Honor. David Schwartz on behalf of Arakaju, Nathan Gwilliam, and Crystal Gwilliam. I think the acceptance of the benefit document is the proper place to start. This case should be dismissed because they voluntarily took $1.3 million. Let me answer Judge Thumma's question about the appeal bond issue. The statute and the rules were changed before this notice of appeal was filed and before the bond was. They did not raise in the trial court the limitation on the net worth. That was never addressed and wasn't an issue. There was not an argument that says, oh, you can't have it for a certain amount because we can't afford it. Was not an issue.
There was never a request to reconsider the bond or litigation?
No, well, not in that sense. There were 4 special actions. There were several motions to stay, but not in addressing that particular issue. Mm-hmm. The law here is very clear. A party who accepts an award or legal advantage under a judgment or order waives the right to review of that decision if it will put at issue the benefit that they received under that judgment or order. That's clearly what's the case here. The $1.3 million covers the entire case. As Mr. Foote said, the issue here is about a forced sale. Okay, so this is directly applicable. He talked about voluntariness, although that's not been a direct part of the incantation from the Dowling case and the Rosen case and the Fink case and all of those. I think it is actually one of the factors that is appropriate for the court to consider is whether or not it was voluntary. But Your Honors have already hit on the important part. It's not the sale, the transfer of the ownership that was voluntary in this case. Is they knowingly went to the trial court. They could have just left that money there and appealed, and we wouldn't be here arguing about acceptance of the benefit. But they took it, and as Mr. Foote has basically told you and has acknowledged to you, they've used that money since. So that money is gone. My clients have now had the burden, if in the event of a reversal, to go after and collect $1.3 million from someone who they now say is impecunious. They've spent all of our money. That's what the Trees case from Utah says you shouldn't be doing. That's one of the purposes here. This was clearly voluntary. This is not like the Del Rio case, which involves specific performance, where they were talking about whether or not the appeal was moot, not necessarily about acceptance of benefit. We don't know what happened to the money in Del Rio. I've read it many times. They don't ever refer to what happened to the money. For all we know, the money sat in the escrow during the appeal, which is exactly what should have happened here. Because what the judge ended up ordering after determining we were the buyer was, as Judge Thuma indicated, it was an escrow. They put their transfer documents in, and we only got them, so there was no legal transfer until we put the money in. That's what happened here. Nothing more, nothing less.
Let me ask you, in your view of the acceptance of the benefit doctrine, which is not covered by a large number of published decisions in Arizona, if the money had not been withdrawn, or released by court order, would that doctrine have any application in this case?
No, I don't believe so. There are things that would relate to what remedies could apply under the mootness doctrine, but not the acceptance of benefit. They'd left the money there, and I said that in my brief. I said it earlier. I repeat it again. If they hadn't taken the money, that's the only basis for acceptance.
And that's true even if they were unable to post a bond either at the full amount or a reduced amount?
That's correct.
Okay.
As to what remedies they would have been, that's a different matter, as I said. They also they incant the words financial compulsion and duress and whatnot, but they don't point you to anywhere in the record to support that. It's their burden to have demonstrated that, either in response to our motion to dismiss or something in the record from below, somewhere in the record to demonstrate that. They haven't done it. They didn't do it. And so we put in here, they do own a home. There's nothing to show Mr. Dale Gwilliam couldn't have gone out and worked while this was all going on. His lawyers had been representing him for, as Your Honors pointed out, 6 or 7 years. There was no foreclosure that was imminent, as was the case in the Arizona Downs case where that kind of language springs from. Not only were there's, in that case, they had gone to the commission, Racing Commission, and said we want certain dates. They gave them a limited number of dates, and they said they wanted more dates. And the court said you weren't required to throw away the limited dates they gave you when you were asking for more dates, because that would have been financially devastating to you, and we're not going to require that. That makes sense. There's none of that here. The money could have just sat there, they could have appealed, and we'd been done with it. Hacken case has nothing to do with this case. Hacken involved a process issue. The appellant in that case was never given the opportunity to even post the bond properly, and so he lost his property before he could do anything. There was no acceptance of benefit issue involved in it whatsoever. I do want to raise a recent case that Judge Thama was involved with, the Grice versus Plaza del Rio management. It was not an acceptance of benefit case. It was a mootness case, but it involves similar to this.
Sorry, the Ponderosa case, did you say?
Grice versus
No,
Plaza.
I'm just teasing. Judge Sama, go ahead.
Is it
Everybody's
Greece?
always talking about what he's written, and we're just annoyed about it.
Oh,
That's all.
okay. Well, I went to a seminar and
For the
Judge
articles, his opinions. We're
Judge
just
Thama
feeling a
told me to
little-
be mindful of mispronunciation, so I thought I was mispronouncing it. Anyway, the Grice case is different. It did involve what they called a shotgun buy-sell, which is essentially what's here, a forced buy-sell. But in that case, unlike our case, there was no release as part of that provision, and so they were only dealing with the issue of whether or not the damage claims could survive, and there was no issue about acceptance of benefit because there was no challenge to what they've described as a forced sale, and what obviously would be a shotgun sale, if you will, to carry that analogy. It doesn't apply to this case. This case is governed by the general principle. There's no exception. Your Honor has already pointed out the Rosen case tells us it doesn't matter if it's before or after, and it would make no sense. So the day before the day after the appeal, they can go out and take all of the money and be as inconsistent as they want. There's no logic to why it would matter if it's before or after. We cited you to the ALR, which says the general rule is it doesn't matter before or after. They've given you no cogent reason why it would in any way affect all of this. They took $1.3 million. They waived their right to appeal. I know you shouldn't have to get this far, but I'm going to address very briefly the merits of all of this. The election of remedies argument doesn't really apply. We sought one remedy for the contract created for Dale William and True North parties to buy us out. That was completely rescinded. It didn't exist. But what was left standing was our offers, which allowed for a unilateral contract. And so from my view, that means we weren't really seeking partial rescission. We sought and obtained full rescission and then specific performance of the terms of the contract, which said should True North fail to elect to buy or sell pursuant to the terms and conditions of this offer within 180 days of the offer being made, a Rockashoe shall be deemed the buyer. But yes, you could look at it in a different way and come to the same result, that there was a partial rescission of not only the contract for them to buy us out, but the underlying original offers which allowed for this unilateral contract. You could look at those in a different fashion and treat those as a partial rescission under the Jones versus CPR or even the Verma versus Store case, because they are totally separable. You can't have both sides buying each other out. It's one or the other. And so in any event, we end up in the same place, and that is it was perfectly appropriate. There were no questions of fact. They were the buyers under the election. They didn't pay. Under total failure of consideration, we were entitled to rescission. Judge Ronan did the right thing and came to the right result. I only want to bring up two very quick little points, unless your honors have any further questions, because they were raised in the brief and they were misstatements from our perspective, and I just want to make sure the record's noted. In the reply brief, they argued that about the issue under Rule 67 and in the inherent authority to enter these orders, making it akin to an escrow. They argued we had never raised the inherent authority in the lower court. That's not true. We raised it both in the original motion for the deposits, EIR 490 at page 4. We raised it again and discussed the very same cases that we put in our in our answering brief at EIR 501, page 8. I think Rule 67 adequately supported it. but I think inherent authority also as well. The other thing I want to just bring to your Honor's attention, again, I don't think you'll need to get to it. In the reply brief, they raised for the first time the argument that, gee, the release in the bills of sale are much broader than the original offers releases because of timing, and they point to one thing. They lost their right to sue us for damages for interfering with their ability to buy us out. Well, number one, I think it's untimely and shouldn't be considered, but more importantly, let's deal with it on the merits. Because this issue is separate from the rescission, if you've already rescinded the contract for them to buy us out, you can't sue us for interfering with that contract. It doesn't exist, as Mr. Foote acknowledged. It destroys, rescission annuls the entire contract. And unless your honors have any further questions, I'll leave it at that. Thank you very much.
Thank you. Rebuttal, Mr. Foote?
I think the court should take judicial notice of this record and what occurred after the or in the time frame when the court was ordering this money transferred and put into the court's registry. The court ordered that the sale be free and clear of all liens. How are they free and clear if they're not paid? There's no evidence that any money was taken out of that money other than to pay the liens, the IRS lien, the attorney's lien. No other evidence. They did not accept the benefits. They were ordered, compelled to do what the trial court ordered, to pay the lien so that the transfer is free and clear.
Didn't the counsel just temporally, didn't the deposit of the ownership documents occur before the release of the money?
Exactly. The deposit of ownership occurred 45 days before the tender of the money.
Well, and I just want to make sure, but you're not saying that that money was used to satisfy those liens which had been satisfied previously? I mean, it may have been
they didn't have the money to satisfy the lien until it closed, and then that money was used to satisfy the liens pursuant to the court order. And if you look in the record, there was about 2 months after it was deposited fighting over the IRS lien and getting the IRS lien taken care of and making sure that the lien of the attorneys was not on the property.
And I understand the IRS lien and the attorney's lien. Mm-hmm. I thought I heard you, and please help me understand this, to indicate that the property that was transferred had to be transferred free and clear liens.
It did.
Those would have been
all the incidences of ownership.
Well, they would have been resolved before closing, right? Would have been satisfied?
They were only satisfied, they were not satisfied in the technical satisfied language. Satisfied means paid. They were not paid prior to closing.
Okay.
They were paid subsequent to closing by the proceeds.
Okay.
It's the only way they could do it. And on the issue of the bond, and if the court goes back and looks, there was arguments that we were not able to pay that. The net worth issue was there. We had a $1.3 million asset. That's the one that was forced to be sold. There was valuation about the house, so all those arguments were made. Whether or not the specific statute was recited or not, I don't recall.
Well, and the reason why I asked that is the statute and the rules, both rules of civil procedure, as I recall, and Arizona rules of civil appellate procedure, were changed in meaningful ways from the perspective of parties seeking to bond off a judgment pending an appeal. That no longer, at times, you could require a super bond, but in general, they favor the party seeking to bond off the judgment, and that's why I wondered if those had been invoked. But believe me, I understand that the record, not only in the direct record in this case, but also special action, that there was considerable effort to work through the bond issue, but just in ways a little different than what that statute contemplated.
And the trial court was stuck on its number, and the trial court couldn't move even despite the evidence that we showed them. So it was a forged sale. I find it curious now that they're backtracking on their position. In their brief, they say it was not a partial rescission. Today they're arguing, well, maybe it is. I think the reason is because they know they lose otherwise. Their only hope is that you kick this out and you don't even look at it, because it is clearly a violation of everything that the judicial system stands for. It's not right, it's not equitable, it's not just, it's contrary to so many precedents. The Arizona Supreme Court, the Court of Appeals, and it's contrary to restatements of the law. You cannot, the court just could not do it. They say you have jurisdiction on that as of that May 23rd, 2012 order. They admitted that in their application, in their response. That, once you get rid of that, the rest of this falls by the wayside. What happens when we go down on a remand? That will be up to the trial court to determine. This court should and must vacate those clearly erroneous, without any equitable reasons, without any legal reasoning, and the reasoning is contrary to the law. I mean, it's impossible to get. I'm just dumbfounded that we got here. But the court needs to vacate those orders, which vacates everything post that time. What will happen when we get down back below? That will be the trial court's determination. What will happen if they can't repay the money? We have so many damages, it may not ever have to be. I don't know, but the trial court, that's where that takes care of. Thank you for your time.
Thank you.
Any questions?
No, thank you.
Thank you.
Thank you both for your presentations. We will take this matter under advisement and issue a ruling in due course. At this time, the court stands adjourned. Thank you.